I'm going to report Chapter 5, Administrative Proceedings. What is administrative proceedings? It is the functions administrative agencies. It is composed of 3 powers: investigatory powers, rulemaking powers, and adjudicatory powers. And sa letter A, acts in both legislative agency between legislative and judicial capacity. It is distinguished to determine the difference of rulemaking and adjudicatory. Then sa letter C, fundamental procedural requirements. From the word of requirements, so dito natin kailangan sundin or ipasa yung mga dapat or kailangan natin gawin. Number 2, character proceedings. Proceeding terminates when appeal has been taken. And letter A, adversary in nature, unfair labor practice procedure before the National Labor Relations Commission, relocation of a license. So, sa letter A, sinasabi dito na yung unfair labor practice procedure, ibig sabihin yung hindi pantay na pagbigay ng mga dapat ibigay sa mga labor, sa mga empleyado. Kaya, dadaan siya sa commission relation. Sa letter B naman, quasi-judicial proceedings before administrative bodies. Yung quasi-judicial proceedings, sinasabi dito na bago pa lang yung administrative bodies, kailangan mo nang matapos lahat yung mga procedures na dapat gawin at ipasa. And lastly, yung letter C, civil, not criminal, in nature particular proceedings before administrative agencies have been held civil rather than criminal in nature, held in departmental trials or proceedings for the discipline of police officers, license, relocations, and quarantine proceedings. So, sa letter C, sa civil not criminal, sinasabi dito yung mga dapat bago mong gawin before yung administrative agencies, yung trials na gaganapin sa civil. Tapos, it is held in departmental trial or proceedings for the disciplines. Ang mga kasama dito na sasali is kasali yung police officers, yung license, yung relocation, tsaka yung quarantine proceedings. Yun yung mga requirements or yung mga procedural requirements na kailangan ipasa during trial. At dun sinasabi yung mga kailangan dapat gawin sa administrative proceedings.
Hi, my name is MIKO and my topic report is about jurisdiction. Jurisdiction is administrative agencies has the power to hear and decide the case. Elements of jurisdiction. Jurisdictions over the person and the subject matter. The scope of jurisdiction of an agency exists as the Constitution, who created them, includes the scope and limitations of its function and the situation where they can act in a quasi-judicial proceedings. Through the case will be then passed on to the courts for proper arbitration and remedy. Jurisdiction cannot be enlarged by a state or agencies. Hearing in administrative proceedings is quite similar to the courts. It requires due process and a fair and just proceeding. Any unfair judgment after a proceedings is considered void and null. Statute can authorize a particular agency to perform an additional duty in certain of situation.
Procedure to be followed. The procedure to be followed before administrative agency is generally not prescribed for ordinary civil actions. Administrative procedure may refer to the performing purely executive or ministerial function or for rulemaking for education. So, meron tayong tatlo. Number 1 is statute or rules. So, when you said statute or rules, it is a formal, written enactment of a legislative authority that governs the legal entities of a city or state. So, the procedure may be prescribed in the statute creating the agency or in the rule promulgated by the agency by authority by law. This agency daw ay nagpo-promulgate and hawak siya ng batas. Rules of procedure governing proceeding before administrative bodies are to be constructed liberally in order to effect just, speedy, and expensive settlement and disposition of disputes between the parties. So, number 2. Reasonable method. The enforcement of statutory rights is not foreclosed by the absence of a statutory procedure. It has been held that where the statute does not require any particular method of procedure to be followed by administrative agency, the agency may adopt a reasonable method to carry out in the function, and it is a well-known rule in proceeding before administrative bodies. Technical rules of procedure and evidence are not binding. So, in reasonable method, pwede siya mag-adapt ng functions in a proceeding administrative. Number 3, informal method of adjudication. So when we said informal method of adjudications, it is a statutory require a decision making and a decision making process that may or not may require a hearing, and it is either formal nor rulemaking. Sabi dito. That's it.
Good day, ma'am. I'm LEMUEL BAYLON. I'm going to tackle about the rules on adjudication under the Administrative Code. Chapter 3, Adjudication. Section 10, Compromise and Arbitration. To expedite administrative proceedings involving conflicting rights or claims and obviate expensive litigation, every agency shall, in the public interest, encourage amicable settlement, compromise, and arbitration. According to Section 10, Compromise and Arbitration, according to the Administrative Code, the two parties involved who has conflicting rights and claims are encouraged to have amicable settlement. Section 11, Notice and Hearing Contested Case. The two involving parties shall be entitled to notice and hearing. Sabi dito na yung dalawang parties ay entitled na umattend sa hearing. And the notice shall be 5 days before the date of the hearing. Sinasabi din na 5 days before the hearing, dapat may matatanggap silang notice. And the notice shall state the date, time, and place of the hearing. Sinasabi din na yung notice na yun, nakalagay dun yung date, kung kailan sila pupunta sa hearing, yung oras, and yung saan gaganapin yung hearing. Number 2, the parties shall given to opportunity to present evidence and argument on all issues. If not precluded by the law, informal disposition may be made of any contested case by stipulation, agreed settlement, or default. If not precluded by law, informal disposition may be made of any contested case by stipulation, agreed settlement, or default. Sinasabi na kapag pinabayaan ng court na tanggapin na lang yung mga ebidensya na binibigay ng kabilang partido nang walang pag-i-examine, sabi pwede raw magkaroon ng agreed settlement or informal disposition. The agency shall keep an official record of its proceedings. Sabi sa number 3, yung agency raw or court na pinaghiringan ay dapat merong nakatabing record ng pinag-usapan dun sa hearing. Lahat ng mga evidence or lahat ng mga sinabi ng bawat partido ay nakasulat. Section 12, Rules of Evidence. The agency may admit and give probative value to evidence commonly accepted by reasonable prudence. Dito, yung court daw or agency, pwede sila mag-accept ng evidence, pero yung evidence na ibibigay ng both parties is kailangan pa nilang i-examine kung ito ba ay totoo or hindi. Documentary evidence may be received in the form of copies or excerpt if the original is not readily available. Upon request, the parties shall be given opportunity to compare the copy with the original. If the original is the official custody of a public officer, a certified copy thereof may be accepted. Sabi, yung documentary evidence is pwedeng i-accept ng court pero hindi pa yun yung final evidence kasi kailangan pa yung i-examine at i-compare dun sa original. Pero kapag ang original copy of evidence is nasa kustodiya ng public officer, yung certified copy is pwedeng i-consider na accepted. Sa number 3, every party shall have the right to cross-examine witnesses presented against him and to submit rebuttal evidence. Sabi dito, every party shall have right. Meron silang right na mag-present ng witness or mag-rebut sa mga binabato sa kanilang nagbigay ng ebidensya. Pwede nilang i-rebut yung ebidensya na yun ng kabilang partido. Number 4, the agency may take notice of judicial cognizable facts and general cognizable technical or scientific facts. With its specialized knowledge, the party shall be notified and afforded an opportunity to contest the facts so noticed. They shall accept the judicially cognizable facts. If there is no available evidence, each party shall be advised and have the opportunity to contest the fact. Section 13, Subpoena. In any contested case, the agency shall have the power to require the attendance of witnesses or the production of books, papers, documents, and other pertinent data upon request of any party before or during the hearing upon showing of general relevance unless otherwise provided by law. The agency may, in case of disobedience, invoke the aid of regional trial court within whose jurisdiction the contested case being heard falls. The court may punish contumacy or refusal as contempt. Sabi dito, the court shall have power to require each party to come to court by using subpoena to show documents and evidence. If the court invoke each party but each of one party refuse the court may punish contumacy or refusal as contempt of.
Good day, my name is GERALDINE VELASCO, and this is the continuation of the rules on adjudication under the Administrative Code. So, Chapter 4, the Administrative Appeal on Contested Cases. Section 19. Unless otherwise stated by the law or the statute, an appeal to a final decision may be taken to the department head. Section 20. Section 20. Perfection of administrative appeal. An administrative appeal may be perfected within 15 days after the receipt of the final decision. If the said appeal was denied, we could use the remaining days of the 15 days given to actually try and perfect the appeal and then file it again. If fortunately it is granted and the decision was reversed, the aggrieved party is given the same rights, the 15 days to perfect his or her defense or appeal. The agency, upon the perfection of the appeal, will transmit it to the appellate court. Section 21, the effect of the appeal. So if the final decision was reversed due to to an appeal, then that decision shall stay. If not, of course, the final decision, the original final decision shall be affirmed or stayed. The action of the appeal. Of course, the appellate court, will review and examine the appeal, and then may require additional evidences in order to determine their final decision. Section 23, finality of the decision of the appellate agency. Upon the decision made by upon the receipt of the decision made by the appellate agency, this decision shall be final and executory within 15 days of the receipt of such decision. Section 24, hearing officers. Each agency shall be given enough competent, qualified numbers of hearing officers in the proceedings, and no hearing officer shall engage in the prosecuting functions in the factuality of the case. Section 25, judicial review. All agency decisions shall be subject to judicial review. The aggrieved parties, or the aggrieved parties in the decision, may seek judicial review as well, and such judicial review may be brought to action against any officer, the agency itself, or any indispensable entities in the proceedings. Of course, the same goes for the appeal, the 15 days to perfect the appeal for the final decision. Section 26, the transmittal of record. Within 15 days after the service of the petition of review, the agency shall transmit the entire record of the proceeding to the court, the original certificate and the entire documents that was used in the proceedings for the appeal or the contested case.
So, magandang araw. Ako si REYNALD CAINOY, and pag-uusapan natin ang controversies among government offices and corporations. So, una, how settled lahat paano ito may isasayos? Lahat ng kontrobersiya sa pagitan ng mga departamento, mga bureau, offices, mga ahensya ng gobyerno, ang instrument ng national government, kasama ng mga pagmamayari ng gobyerno, mga korporasyon na kontrolado ng gobyerno. Lahat ng mga interpretasyon doon, na kontrata, mga pagsundo, kaya makikita sa Book 4, Chapter 14, ang Administrative Code. Subalit, ang mataas na departamento ng gobyerno doon ay hindi kasama, hindi under doon, katulad ng Supreme Court, Kongreso, Constitutional Commission at local government. Number 2, disputes involving questions of law. Lahat ng kaso na involved sa mga katanungan sa batas ay dapat maipasa o maisaayos ng Secretary of Justice bilang Attorney General ng National Government at bilang dating official legal advisor ng lahat ng pagmamayari ng gobyerno o mga kontroladong korporasyon ng gobyerno. Ang kanyang ruling o dapat na desisyon ay dapat maibind o maitali sa lahat ng mga concerned parties. So, number 3. Dispute involving questions of law and fact and law. Ang mga kaso na may kinalaman sa mga halo-halong katanungan sa batas, tungkol sa batas, ng mga facts, factual or mga related na mga issue ay dapat maipasa o maisaayos ng the solicitor ng Solicitor General kung ang mga pag-usapan o ang mga pagtatalunan ng mga kontrobersiya ay involved lamang sa mga department, bureau, offices, mga agencies, ahensya ng national government, mga pagmay-ari ng gobyerno, o mga korporasyong kontrolado ng gobyerno ay siya yung principal law officer. Yun, general o general counsel. At pangalawa yun yung Secretary of Justice. Number 3. So number 4, arbitration. Ang determination ng mga related na mga pag-uusapan na mga issue ay may referred o maipapasa sa isang panel o arbitrational panel o yung binubuo ng mga representative arbitration panel o ito ay binubuo ng mga representative sa bawat grupo at sa pamamagitnaan ito ng representative din ng Secretary of Justice o ng Solicitor General. Ang kaso ay pwedeng maipaapila din. Ito yung panglima, ang appeals o ang apila. Ang desisyon ng Representative Secretary of Justice ay kung aprobado ng Secretary of Justice ay dapat final binding na sa mga involved parties. Ang mga maaring dalhin ay ang apela ay maaring dalhin din sa presidente kung ang halaga ng isang property ay lalampas sa 1,000,000 piso. Ang desisyon ng presidente ay dapat final binding din. And panghuli, ang rules and regulations. Ang Secretary of Justice ay dapat gumawa ng rules and regulation na kailangan under ito sa provision of Chapter 14. Dapat under ito doon sa book sa Chapter 14. And yun lamang po. Yun lang araw.
CATALAN Dominic P. ABPS 33. I am going to report due process of law in administrative adjudication. Due process of law in administrative adjudication. CATALAN Dominic B. ABPS 33. Nature. The right due process is not merely statutory. It is a constitutional right it applies to and must be observed in judicial as well as administrative proceedings to every case, which may deprive a person of life, liberty, or property. The liberality of procedure in administrative action is still subject to limitation by the fundamental requirement of this constitutional guarantee. It is due process requires that legal matters be resolved according to established rules and principles and that individuals be treated fairly. Essence. The essence of procedural due process is embodied in the basic requirement of notice and real opportunity to be heard. As applied to administrative proceedings, it means an opportunity to seek a reconsideration of the action or ruling complained of, as long as the parties were given fair and reasonable opportunity to be heard and to submit evidence in support of their arguments before judgment was rendered and demands of due process are sufficiently met. These are the examples. And standard. Standard is administrative tribunals exercising quasi-judicial powers are thus free from the rigidity or certain procedural. Standard is it the requirements that observed in the courts and sound and settled rules is deemed. Requisites. This administrative due process includes the right to notice, be it actual or constructive, of the institution of the proceeding that may affect a person's legal right, reasonable opportunity to appear personally or with the assistance of counsel and defend his rights, and to introduce witnesses and relevant evidence in his favor by testimony or otherwise, and controvert the evidence of the other party. A tribunal vested with competent jurisdiction so constituted as to give him reasonable assurance of honesty and impartiality. Finding decision by the tribunal supported by substantial evidence pretended at the hearing or at least ascertained in the records. And the right to counsel. While investigation conducted by an administrative body may at times be a criminal proceeding, effect of non-observance, denial of due process constitute grave abuse, discretion, and may result in the validation of the administrative proceedings and the order or the termination entered against a party. Jurisprudence. Jurisprudence seeks to explain in the nature of law in its most general form and provide a deeper understanding of legal reasoning, legal system, legal institution, and the role of law in society. Thank you.
Good day, my name is GERALDINE VELASCO from AB Political Science Section 33, and today I'll discuss to you about the institution of proceedings. The manner in which proceedings are instituted in an administrative agency depends upon the purpose served by the administrative agency itself. So there are three types of this. Number one is it is instituted by a simple application. If an applicant wishes to apply for a license or a permit, or an applicant is claiming a benefit. Number two is the proceeding may be instituted because of a charge or a complaint. Number three is that the administrative agency itself may institute a proceeding by its own initiative because it was provided in the statute. Necessity of notice and hearing. Notice and hearing are not essential in the validity of an administrative action, especially when the administrative body itself acts in the exercise of the executive, administrative, or the legislative function. When the administrative body acts in a judicial or quasi-judicial matter, those who are affected by the rights or the properties of those who are affected may be entitled of notice and hearing. The notice, if you receive a notice or a hearing, it does not actually imply, it does not mean that there is a full-on trial. The due process is actually fulfilled when the aggrieved party has been given the opportunity, the reasonable amount of time and the opportunity to be heard. If the aggrieved party or the affected party did not wish or did not chose to actually state his or her concerns, or he choose to waive his right for the notice and hearing, then he or she could not invoke that there is denial of a due process. Sufficiency of notice. Affected parties are entitled to receive notice and must be given ample amount of time and contents of the said notice or administrative action in order for them to prepare their defense and how the issues should be resolved. Waiver of right to notice. A personal notice is not required, especially when it is impossible for the administrative body to send such notice. And sometimes the parties involved in the proceeding is actually unknown. So the waiver of rights is declared. Denial of due process may be cured. One cannot actually claim that he was denied due process when he was given the chance, or he was subsequently given a chance to be heard and present his or her case. A motion for reconsideration or an appeal is actually curative in character on the issue of alleged denial of due process. Elements or essentials of right to hearing. An administrative proceeding, particularly those who are acting in a quasi-judicial matter, must be fair to all. The full hearing must be fair. Everyone must be heard. There are two elements or essentials of right to a hearing. Number one is the scope of a right. Of course, defendants and or the parties in a proceeding has their different rights. Number one is that to present his or her case or defense. Of course, you want to actually be heard, or you want them to know the reasons of such actions. Number two is that he or she or the aggrieved or the parties must know what is the claims of the opposing party. Of course, you want to know why are you being accused, or why are you being investigated, or why is the hearing being ongoing. Number three is that uh, the the party has the right to cross-examine witnesses. Of course, you want to know if the witness is actually telling the truth, or the witnesses are claiming bad things about you or the administrative body. Number four is that the right to a rebuttal of evidence. I mean, you have to actually um, make sure that you can answer all the questions, or all the claims being thrown to you by the opposing party. The actual hearing is not always essential. The actual hearing or the full-on trial is not actually always essential in an administrative proceedings. As I said earlier, due process is fulfilled when the parties are given when the parties are given opportunity to actually be heard and to present them their case or defense. Duty of the administrative body to consider the evidence presented to them. Of course, in every proceedings, if evidences are shown, the administrative body, acting as a quasi-judicial entity, must uh, must must be fair and check all the evidences. That and not only that the parties must be given the opportunity to be heard. Of course, the administrative body must also consider the evidences shown to them. This is to make sure that the fair trial or the fair hearing is actually being presented in the court, or actually being afforded in the court.
Good afternoon, Ma'am Legaspi. Good afternoon, classmates. My report is all about investigation and hearing distinguished, jurisprudence, requirement of notice and hearing by law or regulation, where provided by law, where not provided by law, courts, investigation, when provided by regulations, and jurisprudence. Let's start with an investigation and hearing distinguished. Match 309 Legal Aspect of Public Administration. Investigation and hearing distinguished. Investigation by government officials, which may be held in private or informal proceedings to obtain information to govern future actions, have no parties and are not proceedings in which action is taken against anyone. In hearing, there are parties and issues of law and of act to be tried, and at the conclusion of the hearing, action is taken which may affect the right of the parties, and parties are entitled to be present in person and by counsel, participate in the hearing, and entitled to be furnished a record of the proceedings. Result of investigation conducted by Court of Industrial Relations prosecutor showed employer guilty of unfair labor practice. Facts: the petitioner, who was employed as pressman in the printing establishment of Asia Printing, was dismissed according to him because of his union activities with the National Union of Printing Workers, of which he was a member. Charges were filed by NUPW against the printing establishment and its manager with the Court of Industrial Relations. Judge P. designated F, acting prosecutor of the court, to conduct an investigation. Finding a prima facie case, F filed the corresponding complaint against Asia Printing and its manager with the CIR. Judge B, after hearing at which both parties, complainant and respondents, adduced their evidence, dismissed the complaint for unfair labor practice. D advances the theory that assuming that the investigation conducted by F was proper and legal, after finding that respondents were guilty of unfair labor practice for having dismissed him for his union activities, then on the basis of the said findings of the prosecutor, the CIR should have rendered judgment in his favor, ordering respondents to reinstate him and to pay his back wage. D also claims that the procedure adopted by the CIR, having the charges filed against the respondent investigated by its acting prosecutor instead of by the CIR itself, is not sanctioned by the law because RA number 875, known as the Industrial Peace Act, does not require any preliminary investigation. Besides, said procedure is disadvantageous to the petitioner in that exposed unnecessarily evidence to the respondent who then knew in advance what the evidence was. Issue is the contention of D that the CIR should have rendered judgment in his favor on the basis of the findings of F tenable? Held. No. Number 1. Investigation conducted by F ex parte. In the first place, according to the respondent, the investigation conducted by F was ex parte. Respondents were not given an opportunity to be present and take part in the said investigation and present their side. That may be the reason why F found a prima facie case against them. Furthermore, said findings that respondents were guilty of unfair labor practice was only a prima facie, made only by the prosecutor and not by the CIR itself. Consequently, it could not be made the basis of decision or award. Second, party first presenting evidence in civil and criminal cases, we see no objection to the so-called exposure of the evidence of the petitioner, unless he wanted to spring a surprise on the respondents. In civil cases, the plaintiff always presents his evidence first, thereby giving the defendant time and opportunity not only to present in giving own evidence but to refute the already presented by plaintiff. In criminal cases, the offended party of complaint invariably submits his evidence first to establish a prima facie case to justify the charges, and in serious offense, preliminary investigation is conducted to establish probable cause before the offender is required to stand trial and to present his own evidence. Third, unfair labor practice to be heard by CIR only after investigation. Under RA number 875 section 5B thereof, the CIR must investigate an unfair labor practice charge filed that said investigation may be conducted either by the court itself or a member of thereof or any agent like the acting prosecutor or a commissioner. Such investigation is mandatory because the law uses the word must. Now, whether it is not regular complaint is to be filed by him depends upon the result of said investigation. It is when a regular complaint based on the said investigation is filed that the CIR intervenes by requiring respondents to answer the complaint, and then both parties are heard to receive the evidence to be adduced by them. Fourth, nearby of investigation. The investigation is really necessary not only for the protection of the respondent but also for the benefit of the CIR itself, so that the respondent may not be required to defend itself against frivolous and unfounded charges, and the valuable time of the CIR dissipated and unnecessarily spent in hearing charges without any basis. Next is requirement of notice and hearing by law or regulation. Requirement of notice and hearing by law or regulations. Where not provided by law, a statute reposing power in an administrative agency to determine particular questions may be deemed to contain provisions for notice and hearing as required by the due process of law. In the absence of express statutory provision, the question whether there is a right to notice and hearing is to be determined by the terms of the particular statute and the attendant circumstances. Where provided by law, there is no question that when a statute requires notice and hearing in reaching an administrative determination, such statutory requisites must be met or the determination is invalid, an express requirement is not necessary. Courts have refused to read a hearing requirement in a statute which does not specifically provide for a hearing. In matters involving mere privilege and not property right, such as liquor, racing, or other such license, although some courts have construed the provision authorizing revocation of a license only for causes as impliedly requiring a hearing. Provision for an investigation does not require a hearing, and the provision for a hearing in one situation or part of the statute may support the inference that the omission of such provision in regard to another situation or in another part of the statute was intentional and meant to deny any right to a hearing as to such matter. When provided by regulations, even if a statute or due process of law does not require notice and hearing in particular administrative proceedings of determinative nature, the regulations of the agency frequently so provided. In such case, the regulations may be held to embrace all the elements of a fair hearing.
Workmen's Compensation Commission or WCC dismissed claim for compensation without passing upon the issue of denial of due process squarely presented before it. Facts. The hearing officer of respondent WCC issued an order of dismissal of a claim for compensation. The order, which charged claimant and his counsel of repeated non-appearance, was precipitated by their failure to appear in the scheduled hearings. The record shows that their failure to appear was due of lack of notice or that the notice were received after the scheduled date. The WCC did not pass upon the issue of denial of due process equally presented by claimant's counsel in dismissing the claim for compensation on the ground of claimant's non-appearance in scheduled hearings. Issue: is the claim of denial of due process meritorious? Held: yes. WCC gravely abused its discretion. The WCC gravely abused its discretion in ignoring and not passing upon this issue. The very rules of the Commission require the giving of reasonable notice of hearing to each party interested by service upon him personally or by registered mail of a copy thereof at his last known post office address, or if he is represented by a counsel, through the latter Section 2, Rule Number 15, Revised Rules of WCC, 1973, so as to ensure observance and protection of an interested party's right to a hearing. Section 1, Rule Number 15, Revised Rules of WCC, patent thereof is the failure of the hearings officer to observe these rules. Under the circumstances, claimant was clearly deprived of his day in court. Consequently, the dismissal of the claim premised on claimant's and his counsel's repeated non-appearance at the aforestated hearing cannot stand.
Hi, good afternoon. My name is VALDYMIR from Day 3 Political Science students. So I'm here to discuss to you, to everyone who is listening in this video, is the topic that given to me. And the topic that given to me and discussed is about here. So constitutional requirement of notice and hearing. So for me, before I will start, I will focus to this constitutional notice and hearing, and I will give the definitions of these three particulars that we need to elaborate or collaborate all these things. Okay, first we discuss the constitutional. Constitutional is about consti. It's about law. It's focusing is focused about the law. What is the meaning of constitutional? Constitutional is set a principles, teach you to set a principles. That's the importance of constitutional law. Second, it depends. It teach you the rules and the doctrines of the law. That's the important to know what is the meaning of constitutions. If we give a sentence, no? Constitution is a set of principles to govern our to lead or to govern our government, to our law. Because as of nowadays, no, we need to be a part of our constitution because we are a Filipino. No? As a Filipino, we need to respect our constitutions that we have a 1987 constitutions. That's connected to the constitution. Next is notice. Ayan. So I will give effort like this. Notice. How you read it? Notice. Notice. Notice is the word notice. How to clarify or how to observe everything. It is notice. My notice to you is about your report. That's the meaning of notice. No, later on I will discuss all parts of this later on. Notice, in short, it's about reminding you, the importance. No, you need to notice the importance. You need to know. It means, in short, you need to know in yourself the meaning, the importance of everything, the importance of your reports. That's the notice. Next is hearing. So hearing, in hearing, the word hear, you need if you connected from the before what I said earlier, notice, notice and hearing is connected. If you notice, you hear from other people who said to you. Hearing is a abstracts to listen, abstracts to know or to construct the words. That's hearing. So, what is the important what I said? What is the main topic or main idea? Yes, we focusing the requirements. And requirements in the book, in the module, if we learn the module, it focusing the fundamentals and essentials of the constitutional requirements. If you read it, the books, you read it some quotations of importance of this. No, I will read something quasi judicial. Later I will discuss about that. And I'll be back to our topic. Yeah, our topic is about constitutional requirement of notice and hearings. In this topic, it's about it's focusing the essentials of a procedural process of law. The word law, it is about the law, and also the about the hearing opportunities to be heard before a court or administrative agency. It's focusing the administrative agency. Okay, and later on the focus also in generally. I will discuss generally focusing about so yun. And in short, the topic, it's focusing the generally the exercise the quasi-judicial power. How you exercise something, not focusing the quasi-judicial power, adjudicatory power, if not I'm mistaken. How you exercise this? For me, as a student, I exercise this power in simple way. You need to learn in your mind and to your heart what is the meaning of that. Or as a student, no, I'm loving so much my I love so much my course. Before that, I hate because of memorizing. Even I'm not good in memorizing, but I love history. So even though I memorize everything. I will tell my story briefly. And what is the meaning of quasi-judicial killing? Quasi-judicial killing is having a party exercising the power. What is the meaning of power? It is to control or to lead his govern, his authority, to how to control the topic. Yeah. So in short, constitutional requirements of notice and hearings is about how you exercise the constitutions, how you exercise the notice, and how you exercise the hearing. As a student, my opinion on how to vital the constitution is apply it and listen to your listen to your teachers, no, what is the process, it's focusing the process also, no, the process due of the law, no, there's something due process of law, there's something, and as students I learn more from my courses, no, the vital role of law, which is the process due of the law, no, there's something due process of law, there's something, and as students I learn more from my courses, no, the vital role of law, which is it is very important to know, especially you and everyone, and me also, as a student, because sometimes you need to carry your constitutional. Yeah. So that's it, my topic. I hope so you understand that in the short, you need to exercise, you need to apply in yourself, and to have a due process of law. No? And you need to know the vital role of a hearing and
Good day everyone. My name is Anthony Lazaro, and tonight I'm going to tackle is about proceeding in which no hearing is required. So in many situations, so a hearing is required neither by statute, regulation, nor by the due process provision. So number one is the due process dependent upon the circumstances. So while a day in a court is a matter of right in judicial proceeding, or it is otherwise administrative proceeding, since they rest upon different principle, the presence of a party is not always so no so not the judicial or quasi-judicial adjudicatory or the government is engaged so in the dispatch of its own internal affair. However, such a proceeding may not be used as a vehicle or depriving a person or constitutionally protected rights without such a hearing. So letter A is there are may mga cases na kung saan ay power or determination and action of quasi judicial character are given affected by which not only property but the lives or individual and may be affected, and which from the nature must be exercised summarily and what a prior a hearing or even notice so the party who may be affected. So good day. This is my continuation of my report. So what is the due process of law? Due process of law is depend upon the circumstances. It varies with the subject matter and the necessity of the situation. So number 2 is the nature of the right affected. Notice and hearing are necessary in order to comply with due process of law. Only when constitutional right is claimed to be invaded and the Constitution does not require a trial type or hearing in every conceivable cases of the government. So, yun lamang po and maraming salamat.
Everyone, my name is CEDRICK LERMA from ABPS 3 and the topics are the proceedings in which no hearing is required. Okay, so nature of power exercise. The requirement of notice and hearing is not essential where the proceeding or power exercise is legislative, executive, administrative, or ministerial in nature and not judicial, quasi-judicial, adjudicatory, or the government is engaged in the dispatch of its own internal affairs. However, such a proceeding may not be used as a vehicle of depriving a person of constitutionally protected rights such without hearing. There are many cases in which powers determination and action in quasi-judicial character are given to officers by which not only the property but the lives of individuals may be affected and which from their nature must be exercised summarily and without a prior hearing or even notice to the parties who may be affected. The Thus, prior notice and hearing are not required. For the summary is abatement of nuisance per se, which affects the immediate safety of person and property, or in summary proceedings of distraint and levy upon the property of a delinquent taxpayer for the collection of internal revenue taxes, fees or charges of any increment thereto, or in the preventive suspension of a public officer pending investigations. The Supreme Court has upheld the authority of regulatory boards to grant ex parte provisional relief upon the filing of an application, petition, or complaint, or on any stage thereafter and without the need of hearing granted to them by law, but it shall call hearing thereon thereafter for the determination of its final decision. The order granting such provisional relief, however, must be based on substantive such provisional relief, however, must be based on substantive evidence supporting papers duly verified and authenticated and with that produced to rendition of the final decision after the hearing. Number 4, waiver of right. The right to a hearing or the right to particular elements of a fair trial may be waived. One must not claim that he was not accorded a hearing or an opportunity to be heard on facts which merely show that he did not avail himself of opportunities afforded for a hearing. Thus, failure to attend a hearing notice of which has been served of a party affects forfeiture of his rights to be heard. In the case, the Supreme Court held that the oppositions or of an application of taxi service who was not able to present evidence in the support of her opposition for failure to notify her at the date of the hearing was not denied due process and she did not show that suffered substantial injury and therefore had no reason to complain and is appearing that she is not moved reconsideration of decision known as new trial for presentation of the evidence.
name is MAGNAYE. So I'm going to discuss about the applicability of rules governing judicial proceedings. So ito yung mga kakayahang magamit ang rules na namamahala sa ating judicial proceedings. So the difference is origin and function of court and administrative agency preclude the wholesale transportation and administrative proceedings of the rules of procedure, trials, and review which evolve from the history of courts. So ito yung pagkakaiba ng pinagmulan at pagpapatakbo sa mga court or agency ng administrative proceeding na nagsusubok at nagsusuri sa mga nagbago sa history ng court. So 1. Strict legal rules not applicable. Usually, the procedure of administrative agency is not as formal and strict as that of what the court, and the regularity of such proceeding is not be tested by the strict legal rules which prevail law courts. So, ito yung pamamaraan ng administrative agency ay hindi siya formal and strict kagaya ng court, and in the way ng paglilitis ay hindi dumadaan or nasubok in legal proceeding which nagpe-prevail kagaya sa law courts. So A. The atmosphere of administrative tribunals may be one of expeditiousness, expertness, or liberally conceived remedies. So this is the environment of tribunal na pang-administrative for them na nagiging isang pagiging magaling sa magaling para maging maayos ang lahat. So B, all the instinct rules of evidence governing judicial controversies do not need to be observed. Only such as are fundamentals and essentials like the right of cross-examination, hearsay, evidence may even admitted provided the party invested given the opportunity to explain or rebut it. So ito yung mga kailangan gawin or nagiging basis and importance ng cross-examine na magiging evidence at maaaring tanggapin kahit na ang parties ay binibigyan ng chance to explain, magpaliwanag. So C, conduct proceedings before administrative agency have consistently required some proof of authenticity or reliability as a condition for the admission of documents. So, ito yung pagsasagawa or paglilitis bago yung administrative agency, yun yung nagpapatunay ng liability para magpasok ng mga dokumento. Two, due process requirement to be observed. So, ito yung mga kailangang sunding process. Although administrative agency are, as rule, unrestricted by the technical or formal rules of procedure applicable to courts in the adjudication of cases, administrative agencies, the same court must act within. So, even though yung mga agencies ng administrative ay hindi masyadong mahigpit sa patakaran ng paraan ng paglilitis ng kaso ng pang-administrative agencies court pa rin yung dapat nakilos through in the cases. An administrative agency exemption from strict legal rules of procedure does not empower it to act arbitrarily, and even the statutory exemption from rules of procedure cannot authorize exemption from due process guarantee in the exercise of quasi-judicial powers. So, ito yung isang pagpapatawad na ahensya from mahigpit in legal na mga policy or rules na mga pamamaraan ay hindi nagbibigay ng kapangyarihan na ito'y kumilos sa pagiging arbitrarity kahit na ang statutory exemption mula sa mga rules sa pamamaraan ay hindi maaaring pahintulutan ang exemption mula sa angkop ng garantiya ng pagpapataw ng quasi-judicial powers. Due process, however, is an administrative context does not require trial-type proceedings similar to those in courts of justice. So, ito yung mga nararapat na process, but isang context in administrative agencies na hindi nangangailangan ng paglilitis sa uri ng pagsubok katulad ng mga sa Court of Justice. So, ayun lamang po. Salamat.
My assigned topic is all about delegation of authority to power and receive evidence. In the delegation of authority to power to decide solely in the administrative agency vested by law, it does not preclude the delegation of the power to every person like hearing officer, examiner, or investigator to receive the evidence, hold the hearing, and make them into reports on the basis of which the decision of the administrative body or agency. The term administrative body or agency includes the subordinate officials upon whose hand the body of or agency delegates in a portion of its authority. Number one, essential that the judgment of discretion are finally exercised by proper officer. The rule is that the administrative officer whose exercises his own judgment and discretion does not preclude him from utilizing, as a matter of practical administrative procedure, the aid of subordinates to investigate and report the fact of the basis of which the officer makes decisions. Judgments and discretion were exercised of those officers authorized by the laws. Number two, essential that due process requirements are observed. This means that the requirement of a fair hearing, the actual taking of testimony before the officer who will make the decision in the case, as long as of the party is not deprived of his right to present his own case and submit the evidence. There is no process. There is no question when the requirements of due process and fair trial are fully met. In short, there is no abnegation of responsibility on the part of officer concerned, as actual decisions remains and made of said officer. Number three, the essential that proper officer acts on his own independent judgment. The officer must make the determinations upon the evidences. The determination must personally consider and appraise the evidence which justifies them. The officer must act his own independent consideration of the law and the fact of the controversies, not simply accept the views of recommendation of subordinates in arriving decision.
Good afternoon everyone, my name is EVANDER MIRALLES and my topic is about evidence in administrative proceedings. Number 1. Application of strict rules of evidence. The very obvious purpose is to free administrative bodies from the compulsion of applying technical rules so that the mere admission of the matter would be deemed incompetent in judicial proceedings would not invalidate the administrative determination. The prerequisites o ang mga pangunahing pangangailangan sa pagtanggap nito, dapat ito ay relevant, materiality, and competent o ang kaugnayan nito to be used as an evidence. Number 2, particular judicial rules. This view has been applied in regards to the best evidence rule or res inter alios acta, or in English, a thing done between others does not harm or benefit others. Or kung ano man yung transactions between two parties, it should not be used against a third party.
Admission and declarations. Dying declaration is the testimony that would normally be barred as heresies, but may be common law nonetheless, be admitted as evidence in criminal law trials because of its constitute the last word of the dying person. Self-serving declaration as general rule excluded means that not included in administrative proceeding. Evidence offered during the hearing. So all evidence that should be present in the court during hearing must be fully and fairly appraised. The decision in hearing must be defended under the evidence that they had been presented. Evidence without rational probative quantum or proof. The evidence of guilt must be strong before established to admin tribunal, the one responsible for settling dispute between private and public entitles, but it's not satisfied with balancing of interests. It is also not required evidence demonstrate their claims that 50% chance of truth, while in our jurisdiction, it is required and must be supported by substantial evidence. Jurisprudence, the court and trial system used to administer the law and justice. Agency files and records. So the court says it is inappropriate of an administrative agency in quasi-judicial that they base their decision from their own files. On the other hand, there are cases holding that an administrative agency can take judicial notice of its own record. Secret and confidential information. It is a general rule that an adjudicatory proceeding involving primarily the interests of private litigants. Information cannot be withheld from the parties on the ground that it is confidential nature and at the same time be used as a basic for decision an administrative agency.
Day to everyone. I am Eunice N. Ramos, today's reporter, and I'm going to discuss the matter of decision or orders, which is also part of administrative proceedings. Number 1. Necessity of findings. It is the right to adduce evidence without the corresponding duty on the part of the administrative agency to consider it to consider it is vain. Letter A. While the duty to deliberate does not often impose the obligation to decide right, it does imply a necessity of having something to support its decision. A decision or order with absolutely nothing to support it is a nullity at least when attacked directly. The decision must be based on the evidence presented at the hearing, or at least contained in the record and disclosed to the parties affected. B. The necessity for a finding to sustain administrative action, adjudicatory or quasi-judicial in character, does not rest wholly upon a statutory requirement of finding, but may exist even in the absence of specific legislative requirement. Furthermore, express findings are necessary or desirable. 1. So that it may be known upon what the action of the administrative agency is based, as well as to protect and assure the parties against careless and arbitrary action. 2. To enable the courts to perform their function of review, particularly to determine whether the administrative agency has kept within its jurisdiction and decided the case upon the evidence in the law. And last, 3 is to give the reviewing court the assistance of an expert judgment of the matters entrusted to the agency for initial determination. And now let us go into number 2's topic, which is form. It is administrative decisions or orders must in particular cases conform to the statutes and the rules of the agency governing the particular proceeding, as well as the applicable constitutional prescriptions. A. They must be in proper form, authenticated as prescribed by statute, and must be entered against the proper party. They should be sufficiently definite and certain to inform the party what is required to be done, and to enable the courts in proper cases to enforce them. B. The mandate imposed by the Constitution to state clearly and distinctly the facts and the law on which law decisions is based refers only to a court. It does not mean, however, that the non-inclusion of administrative tribunals within the scope of the constitutional provisions justifies the summary disposition of controversial factual questions. And my last topic is about finality. With respect to decisions or judgments of lower courts or tribunals, the general rule is that they become executory only after they have become final and executory. Execution pending appeal being an exception to this general rule. A judgment becomes final and executory after the lapse of the reglementary period of appeal, if no appeal is perfected, or an appeal therefrom having been taken, the judgment in the appellate court becomes final. Also, there is no general legal principle that mandates that all decisions of quasi-judicial agencies are immediately executory. Where the legislative has seen fit to declare that decision of a quasi-judicial agency is immediately final and executory pending appeal, the law expressly so provides. Decisions of the Securities and Exchange Commission and the Civil Aeronautics Administration, for example, are not immediately executory and are stayed when when an appeal is filed before the Court of Appeals. On the other hand, the decisions of the Civil Service Commissions under the Administrative Code and the Office of the President under the Local Government Code are immediately executory, even pending appeal, because the pertinent laws mandate them to be so. So that's all about my today's report. So that's all my today's report. Thank you.
Hi, I'm MIKO and I'm going to report the administrative agency is a collegiate body. The power of duties of administrative agencies or board composed of members or commission may not be exercised by the individuals members separately. So their act are official only when done by the members convened in sessions upon concurrence of at least a majority and with at least quorum present. Where the actions needed is not of the individual composing board, but of the official body. The members must be together and act in their official capacity, and the action should appear in the records of the board. In case when the former immigration commissioner appeared to have individual, they are not collectively as a board to discuss and vote on a signature. The Supreme Court nullified the decision rendered individual action by members of board plainly renders nugatory and purpose of its constitution as a board. The legislature organized the board of commissioners precisely in order that they should deliberate collectively and in order, but their views and ideas should be exchanged and examined before reaching a conclusion. This process is of the essence of the boards of action, save where otherwise provided by law. And the salutary effects of the rule will be lost where the members act individuals without benefits of discussion.
So, good day everyone, my name is Paulo Adam Sibunga, and today I'm going to discuss to you the application of doctrine res judicata. So, the words may not familiar to us because it is a Latin word, which means when you translate it into the English, it says that res judicata means a matter of already judged. So, in the definition, it says that the res judicata, it is a method of preventing injustice to the parties of case supposedly finished, but perhaps mostly a way of avoiding unnecessarily waste of resources and the court system. So this decree does not merely prevent the future judgment. contracting earlier, but also prevent the litigants from multiplying the judgment and confusion. So that means that the main purpose of this decree was to give a justice or to justify the specific case as soon as possible, or shall I say, or in the other word, it's solidify, or shall I say, it is give the justice early, as soon as possible. And in the case of res judicata, the matter cannot be raised again either from one court to another court, or shall I say to a different court, if the court will use, or shall I say declare, that case is a res judicata, or they apply the decree of res judicata to deny the reconsiderations of a matter. And that's So this is the continuation of my report, which is the elements of this juriscara, or a doctrine of res juriscara. It is typically the basis, or yes, the basis of the court before they apply this doctrine to the certain cases. So first, it says that res juriscara is a dependent type of determination in proceeding. So that means that it is very important to know that this type of decree has been applied to the administrative actions. So it is an actions that characterized, of course, by the court, because the court will be the one to perform this. The court will justify the cases. The court will solidifies the cases before they perform, or before they apply this type of decree, because we've already know that this decree can easily give the justice, but at the same time it is intended to study the case, because of course justice, committing justice is very hard, and at the same time it is very important to learn from it. So it is said that it is recognized particularly in regards to those type of administrative actions, so in which that administrative actions, or shall I say administrative agency, was not a party. So that means that the court should know the different shall I say the execution of the cases and the specific situations, and at the same time it basically know all the story of the case before they apply this types of decree. Next is as unaffected by stationary provisions. So it says here that some statute was may limit or restrict to extend which the administrative may operate as a res juriscara, or shall I say it's the decree, where essentially plainly complaint that this independent valuation properly should be made for 8 years. So yes, it is years. So because before they proceed to this, before they apply this decree, they need first to study hard to know the root of the case, and of course to know the whole statement of the case, enable us to perform this, or shall I say to apply this case, because having, because this the purpose of this is the purpose of the res judicata, or this doctrine was to commit the justice early, or shall I say as soon as possible, but at the same time the court need to study first, and of course they has a different type. They need to undergo some of the tests, some of the articulations, and at the same time, or tinatawag nating paglilitis, so that they can create, or shall I say, before they can apply this doctrine to the case, so that the case will ended as well. Because napakahirap kalabanin ang makakuha yung justice. Before mo makuha yon, dapat dapat alam mo, at saka at the same time the facts, yung katotohanan, so that you can commit justice. That's why sometimes strictly in-extend nila ito ng for almost 1 year. And lastly, as to administrative decisions, judicially reviewed. So, as I mentioned earlier, the court will review the cases before they apply these types of doctrine, because where that's the administrative determination to review by the court. So of course the court will be the one to review, because the court knows how to the strategies. They already know the strategies, enable us to know to give the justice and at the same time to solve the cases early as soon as possible, so that that's why they need first to review from the start regarding those specific case, enable us to as soon as possible they can so-called apply these types of doctrine. So as a matter of fact, the court will be must be sensitive, trying hard, and at the same time the court will of course review, and that's it, review to solidify those arguments, so that they can know the facts regarding those cases which is applicable to the doctrine, and at the same time they can easily apply the doctrine without hesitation.
Hi, my name is MIKO and my topic report is about administrative appeal and review. In many administrative systems, there is a hierarchy of authorities, so that by express provision of statutes or otherwise a review may be had within the administrative system itself of the action of lower administrative authorities by their superiors or particular administrative body is authorized to hear and decide the appeals from the review and determination of certain other administrative bodies or officers. And they are different types and kinds of administrative appeal and review. Number 1, in the relation of administrative superiors to administrative subordinate, where determination are made at lower levels of the same agencies or department. Number 2, the embrace The embrace statutes which provides for a determination to be made by a particular officer or body subject to appeal review or determination by other officer or body in the same agency or in the same administrative system. Number 3, that in which the statute makes attempts to make court a part of administrative scheme by providing in terms of or effect the court on review. So, the action of administrative agency shall exercise powers of such extent that they different from ordinary judicial functions and involve a trial o de novo of matters or fact or discretion and application of the independent judgment of the court. Number 4, the statute provides that an order made by division of commission or board has the same face or same force and effect as it made by the commission subject to rehearing by the full by the full commissions for the hearing is particularly an appeal to another administrative tribunal. Number 5, the statutes provide for an appeal to an officer on an intermediate level with subsequent appeal to the head of the department or agency. Number 6, the embrace in statutes which provides for appeal at the highest level, namely by the President. In order to be entitled to review by an appeal administrative body of the determination of subordinate or another administrative body as a party must have been affected or aggrieved by it and must, so that they can only prove.
Good day everyone, my name is Janine Pintor. I'm going to discuss the action by Administrative Appellate Tribunal. So we have authority to reverse must be exercised sparingly. While there is no disputing the authority of administrative superiors to reverse the findings of their subordinates, this power must be exercised sparingly and only upon a clear showing of errors. Lacking such flow, the decision of the lower administrative offices should be sustained. Why? Because they have closer access to the problem sought to be resolved and have direct opportunity to question the parties and their witnesses and to assess the evidence in the first hand.
The second is, review must not be arbitrary.
The review must not be whimsical or arbitrary or devoid of substantial basis. Thus, although the power of the Presidential Assistant of Legal Affairs acting on behalf of the President to reverse the decision of department head who is higher in rank is conceded, it must be exercised like all powers within the limits of the law. If substantive rights are to be protected and justice is to be upheld, the President, directly or through the Executive Secretary, may review, affirm, reverse, or modify the orders and decisions of a Department Secretary by being his alter ego, subject to his admin's control. The third is review generally de novo. The scope and extent of review in the administrative system will depend upon the statutory scheme of distribution of powers as between the officers or body making the initial decision and the officer or body making the decision on review, and the provision of the statute and administrative rules in regard to the review itself. Generally, a de novo review is required unless the law provides otherwise. The fourth is, review officer must be other than officer whose decision is under review, in order that the review of the decision of a subordinate officer might not turn out to be a farce. The reviewing officer must perforce be other than the officer whose decision is under review. Otherwise, there could be no different view or there would be no real review of the case. The decision of the reviewing officers would be biased view. Inevitably, it would be the same view since being human. He would not admit that he was mistaken in his first view of the case. It would violate a fundamental aspect of due process and make a mockery of administrative justice. And the last is final and executory decision not subject to review. Under Section 15, Chapter 3 of Book 7 of the Administrative Code of 1987, it says that decision of administrative agencies become final and executory 15 days after receipt of a copy thereof by the party adversely affected unless within that period an admits, appeal, or judicial review, if proper, has been perfected. One motion for reconsideration is allowed. A final resolution or decision of an administrative agency also binds the office of the President, even if such agency is under the administrative supervision and control of the latter.
Good day. My name is Geraldine Velasco of AB Political Science Section 3.3. Today, I'll discuss to you about the enforcement of administrative determinations. First, let's define administrative determinations. These are the decisions or orders made by the administrative bodies. Administrative determinations are enforceable in a manner provided by the statute. So, if the statute is incomplete or it does not provide the manner of enforcement of such determinations, then it is unenforceable. The legislature may aid in the enforcement of such determinations by simply providing a penalty for the failure to promptly comply with the determinations, and a direct and positive sanctions such as the grant of subpoena or the contempt powers of the administrative body. These are afforded for the administrative and judicial processes of the determinations. This is actually used to compel obedience and to prevent, the violations of the determination. Administrative enforcement. In the absence of a statute or a law, the administrative authorities has no power to enforce their determinations. It all boils down to the completeness of the statute itself. So as long as the statute provides that the power of enforcement to an administrative body, then it can enforce their determinations. So there are different methods used to enforce administrative determinations. So an example is the focusing of public opinion. Second is suspension, revocation, or cancellation of license, mostly done by the Professional Regulation Commission. As an example, when a doctor does a malpractice in his line of work, the PRC may cancel, suspend, or revoke his medical license. They have the power to do such. Another is the delay of the withholding or the denial of benefits. This is done by the SSS. For example, when someone has died and his or her family member tries to get benefit out of SSS, the SSS may deny them so if they could not complete, paperwork. Of course, the SSS has the power to deny them of such unless, of course, otherwise the paperwork are done. And of course, until they know that you are the real beneficiary of the deceased. Other methods are the cancellation of clearance papers on ships, mostly done in the piers or the ports. Those at the administrative body there, they tend to cancel clearance paper or delay the renewal of clearance paper because of some mistakes done by the ships or the shipping company. Other methods also applies to another method is the deportation of aliens. When a foreigner, someone from out of our country, someone who is not from our country, let's say an American, commits a mistake here in the Philippines, the Bureau of Immigration has the power to deport them. So it is an administrative determination whether or not to deport such a foreigner because of a mistake. So I will put the list of methods for enforcement in the list after this. Next is, it is within the competence of the Congress, while they do their lawmaking jobs, to make sure that the statute or the law is complete. Meaning, it has also provided sanctions for the enforcement of the determinations. As I said earlier, if the statute is complete, then the determinations of the administrative body can and may be enforced. If not, if the Congress has failed to provide, or if the law has failed to provide such remedies or such provisions for the enforcements of their determinations, the only resort of the administrative body is to go to court in order for the court to make their determination enforceable. It will now become as a judicial function. But although the Congress has tons of power, they have no power to authorize a purely administrative officer to determine whether the crime has already been committed. The crime defined by law has been committed by someone and then inflict punishment to them. That function is actually a judicial function. So, although they have powers, or the law they make has powers to provide power of enforcement to the administrative bodies, they cannot invest powers of determining whether someone has actually committed it and to inflict punishment to them. That is a judicial function. The penalties and the surcharges or other obligations, but that is determined in the determination by the administrative body, is considered or regarded as civil or remedial rather than criminal or punitive. This means that if you were accused, or if someone has filed a case, a civil case, it becomes a civil case, not a criminal case. So even if you lost in such case, the punishment of imprisonment is not actually allowed. That such is a judicial power. The courts has the right to give such heavy punishments. The penalties and penalties and surcharges are considered civil. So once you pay the penalty or the surcharges, then you're free to go. No need to go to jail, actually. when there are irregularities in the issuance of execution or writ of execution, this should be discussed in the administrative tribunal. This is where the quasi-judicial function or the quasi-judicial power of the administrative body comes in. No need to burden more the courts, the Court of Justices, because they have like tons of cases to review as well. And this is also for the advancement of justice, and so to correct as well the errors of the ministerial officers, and so also to control the process of the administrative procedures. Next is the judicial enforcement. Generally, the administrative agency or the administrative body has no power to enforce their determinations. This is actually a judicial function. But unless, of course, otherwise, it is provided in the statute. Everything boils down to the completeness of the statute itself. If the statute or the law provides that the administrative body has the power of enforcement, then it could do so. So the statute, once they have provided the provisions or the power of enforcement to the administrative body, they can enforce their determinations. Upon the enforcement proceedings of a administrative determination, or if the administrative determination is in question and it was filed in the court actually looks into the color or the legality or the authority of the administrative body to enforce the determination. It does not look into the case itself. I mean, the courts could not be bothered with the evidences of the case, but it questions the legal authority of the administrative body to enforce such determination. And as long as it does not violate any constitutional rights and the statute has actually provided for its power of enforcement, that is all that the judicial courts focus on. So when the court examines in the proceeding examines the administrative determination, it is not just because the court has to accept the determination and issue a enforcement, or it is not like the court is an executioner of the administrative bodies. We could not burden the judicial or the courts anymore with another case to review. Of course, unless there are constitutional violation happening, the court only focuses on the legal authority of the administrative body itself. When an administrative determination is filed into a court, or if someone is arguing with the legality of the administrative determination, and then the court decides whether or not to actually enforce the determination, that decision becomes a judicial order, not an administrative order, because the judicial function or the judicial power has laid over the administrative power. So when the court has decided on the case, it becomes a judicial order, not an administrative order anymore. Lastly, we have the execution pending appeal. This is actually an exception to the rule that The execution of a decision takes place only when it is final and executory. So thus, the exception is execution pending an appeal. When the legislative department or the legislatures has seen it fit that the quasi-judicial agency or the administrative body, in good reason, they may actually enforce their determination in a manner as an exception to the rule, which is it is immediately final and executory pending an